When it comes to estate planning, don't forget about alternates. This is estate planning lawyer Michael Pevney, and I create estate plans for California families. If you've got any questions about this or anything else related to estate planning, ask a question in the comments. I'm often able to get back to them. So let's talk about 4 things when we're talking about alternates in estate planning. First, if we're a traditional couple and we want to leave things to our kids, whether that's by a will or by way of trust, I create trusts for most of my clients. Oftentimes we need to ask the question, if a worst case scenario happens and you want to leave something to your child and your child passes away before you or predeceases you, and they leave children of their own, your grandchildren, do you want that child's share to end up going to their children or to your grandchildren? And if that is the case, it's typically the case for most of my clients. If that's the case, under what circumstances do we want them to receive that inheritance? Because maybe the kids are in their 30s or 40s and grandkids might be in a single digit age. Maybe they're even infants. So how do we want that money distributed? Do we want them getting everything as soon as they turn 18 without any strings attached? Or maybe we want them to receive that money in trust with some sort of strings attached to it. Maybe it can only be used for their health and their education up until they reach a certain age. So another scenario, second scenario, is maybe we want to leave something to somebody that's not necessarily a child, and we want that money to go to a good friend or a close relative, or maybe a niece or a nephew. And maybe for whatever reason we don't want something to go to their own children, that beneficiary's child, when they pass away. And so in that case, we want to make sure that we name an alternate. So like if it's a group of 3 or 4 people that we're leaving the bulk of our estate to, maybe do we want that person, if they pass away before us, maybe we want their share to go to the rest of the other 3 people. So maybe we don't have any children, we have siblings that don't have any children, and we want to leave things to our siblings. One of our siblings passes away before us. Maybe do we want that deceased siblings' share to go to the rest of the people that we're leaving things for? We want their share to be equally divided among the rest of the class or group of people that the rest of that our deceased's share is going to end up going to. Or that person's share can go to a specific named person, a specific charity, something like that. Estate planning, especially when you use a trust, a revocable living trust, gives us so much variance and so many options and so many alternates that you can take care of. Because what often ends up happening is if we just have one if we just have one beneficiary, one person that we want things to go to, and maybe that's not a family member, maybe we choose not to give things to our family of origin, we are going to be stuck with, and this is the third point, if we don't name people, we don't name alternates, we are going to be stuck with the state that we live in's their estate plan. And so they've created these rules that they think might be what people might want if you pass away without some sort of estate plan, but it's not necessarily what most people want. So first it will look at children. Do you have children? I'm talking about California's rules for the most part. And if there are no children, it's going to look at, is there a spouse? Community property rules. There has to be some sort of a division there. And then if there are no children, then it's going to look to parents. And if there are parents still alive, if there are no parents alive, then it's going to look to siblings. And if there are no living siblings, then it's going to look to nieces and nephews. And then it goes beyond that to aunts and uncles, and then first cousins, and then even beyond that, all the way out to different degrees of separation, up to the point where, at some point, these things are going to be left to family members that you might either not have a close relationship with, or people that you might not even know or even have ever met. Maybe they live on the other side of the country. Maybe there was siblings that were estranged. You have that aunt or uncle that you never had a relationship. Do you want your property going to them, or do you want basically to choose alternates, whether that is a close friend that is like a family member? But remember, if there's no blood relation or no marital relationship, nothing's going to end up going to them unless you specifically state that in your estate plan, in your will, in your trust. So it's important always to think about and to name alternates. And when we write all of these things down and they're properly witnessed or properly notarized, and again, for most of my clients, this ends up being done in the context of a trust, a revocable living trust. And so if at the very worst, if there's no living relatives, right, there is this old term that most people have forgotten about, even if they went to law school, and it's called escheat. And that means that all of your property, if there's nobody left, no family members, and you don't have a proper estate plan in place, it is literally going to go to the state. It escheats to the state, meaning if you're in California, the state of California is going to end up getting that property. Doesn't matter how much is in there. It could be a huge, massive amount, millions of dollars. So the solution to all of this is to create a comprehensive estate plan. Make sure you include alternates in all of this. And by the way, I'm not just including people that are necessarily going to inherit your property. I'm also talking about people that are going to make financial decisions for you and healthcare decisions for you. We always want to set up a power of attorney, a financial power of attorney. And if that person doesn't want to serve, maybe they're medically incapacitated, or maybe they're gone, maybe they're dead, we always want to have at least one alternate. Same thing with healthcare decisions. We want a primary, we want at least one alternate, and we need to think about, well, maybe how old are these people? What's the likelihood that they are not going to want to do this, that they might pass away before we do? So estate planning, a big important part of this is to think about, if heaven forbid somebody's gone before us, who do we want that alternate to be? Who do we want to inherit things if our beneficiary, the person that we've selected, passes away before we do? So I'm a California estate planning lawyer. If you've got questions about this or anything else related to estate planning, follow me on whatever platform you're watching this on, and go ahead and ask an estate planning question in the comments. I'm oftentimes able to respond to those. Thanks for watching, and thank you for your attention.